right, so we've got some related appeals here. Mr. Barbie, did you want to reserve any time for rebuttal? Well, we can't see or hear you, Mr. Barbie.
Hi, judges. It's Callie. Mr. Barbie is reconnecting as we speak.
Thank you, Kelly.
Do you hear me? Why are they doing this?
All right, Mr. Barbie?
Yes, I think it says the host has disabled my video.
All right,
when I try to put
all
video.
Right. Can we reconnect Mr. Barbie's video?
Okay, I got here. Here we are.
There we go.
Here we
all
are.
right. All right, Mr. Barbie. So all I said before I realized that you weren't here was that, we've got a couple of appeals all being heard together here, and I wanted to know if you would like to reserve any time for rebuttal.
Yes, I would like to reserve 5 minutes for rebuttal.
All right, very good. And then Mr. Marr and Ms. Klimt, would you, how are you going to divide your time, or have you decided how you're going to divide your time?
Your Honor, we were going to play it a little bit by ear based on questions that the panel might have.
All right. Well, then I guess when it's your turn, you'll have to let me know who's going first.
Well, I think if I may, there are 3 appeals.
Yes.
One of which is a cost fee application, 2 of which are main case motions, and so I think I'll probably go first.
All right. Very good. All right. So, Mr. Barbie, you're reserving 5 minutes, so please begin.
Thank you. In this case, when the case first started, it got off to a bumpy start because it was a last-minute bankruptcy filing. And Judge Montali found that Coeptis, as a LLC, should not be debtor in possession. No creditor made a request that Coeptis not be debtor in possession. It was something that Judge Montali did sua sponte. He also kicked me off the case. So at the time of the order to show cause, I think I might have still been the lawyer, but at any rate, the law says that a party has to be the one to request that the debtor in possession be removed. That has to be something initiated by a party. The court was not a party. It's talking about a creditor or someone of that nature. The judge just did this totally sua sponte. The respondent, they argue that, well, he has the right to do that because courts can do things sua sponte. However, a court cannot sua sponte remove a receiver. And I've cited numerous cases that clearly show that a bankruptcy trustee is a receiver. They're doing the exact same thing. And that
why? But as a matter of statutory, interpretation, you cite the prohibition to court sua sponte appointing a receiver, and so the receiver is used in that section of the code, and then there is a plethora of use of trustee throughout the remainder of the bankruptcy code. Those 2 terms cannot be coextensive, can they?
I believe that they clearly are.
Well, we don't. I mean, bankruptcy does not appoint receivers. There's not a receiver for the administration of Chapter 7. Ms. Klump is not a subchapter 5 receiver. So, I mean, trustee is a fairly well-defined term of art within bankruptcy, isn't it?
Well, my research showed that in this particular case, where a debtor in possession is removed and a trustee is installed in order to manage the estate, they're acting as a receiver.
Well, they're
saying that
they're acting within functions that may be a receiver, but trustee is statutorily created and governed within bankruptcy, right? Whereas a receiver is not within bankruptcy. So it seems like those two are different, although the functionality of the two may be similar.
Okay, well, I don't know if the court noticed, but this Barton case, which is a Supreme Court case, established the rule requiring litigants to obtain permission from the bankruptcy court before filing a lawsuit against a bankruptcy trustee. Yet the rule from Barton, which expressly applies to bankruptcy trustees, if you read the case, it talks about receivers. The whole case talks about receivers, even though it's applying it to bankruptcy trustees. So if you look at the Webster's Dictionary or Oxford English Dictionary definition of a receiver, it coincides with the definition of what a trustee does, which is manages the estate to keep it from going into waste. But also, Judge Montali didn't give us any time to respond. I mean, it was like, I can do whatever I want. He said it, and then it was like a few days later. It was not 21 days. It was not 28 days. It was like, we're going to have this hearing, and we're going to do whatever. And just remove Coeptis.
You say whatever, but wasn't the court concerned about the insurance situation and the lack of prompt activity by the debtor to do things that are traditionally expected of debtors, including cash collateral management?
If that were a concern,
that's a concern with every Chapter 11, where there is a secured creditor and cash collateral. I mean, that's why they call it first day motions. Is it has to be brought promptly.
When the U.S. trustee or one of the lenders on one of the properties or someone like that could have said, look, our interests are being jeopardized because this person isn't doing their job. We want this person to be removed. If they're not complaining, the judge should not have complained. It was not right.
It should not have complained. That goes against a fairly well-established
requirements of the code.
A code and the court's obligation. I mean, going back to Espinoza, that the court has to apply the bankruptcy code. That is the bankruptcy judge's obligation.
So, counsel, the other problem here is that you didn't appeal from the removal decision. You waited 5 months until the case was converted, and then you filed an appeal from the conversion order and included your appeal from the removal order. So we're only looking at this point, right, at the denial of your Rule 60B motion.
Right. Well, the truth is, Judge Montali found that I was not competent, so he removed me, put in a different attorney, and that different attorney would have been the one in place at the time for the appeal.
I'm not blaming you. I'm just suggesting that Coeptis doesn't have a position today that they have the right to attack the underlying ruling. They only have a right to attack the denial of the Rule 60B motion. That's all I'm pointing out, correct?
No, I understand with the court. I thought the court would bring that up. The fact is, you can't really argue whether or not the denial of a 60B motion was an abuse of discretion without looking at the underlying claim. And the underlying claim is that he did this sua sponte, and the statute itself says that an interested party such as a creditor, a lender, is the one that initiates that. Plus, he only gave us 13 days between the issuance of the OSC and the removal of the debtor in possession. And my understanding is that removal of a debtor in possession is something that rarely ever happens, and we only had 13 days to respond to it.
Counsel, if you didn't like it, you had 14 days to file a notice of appeal, and nothing happened for 5 months. So I'm not sympathetic to the argument that you only had a short period of time, because you could have appealed from that decision. Whether it was you or the other counsel, somebody needed to do something. But what I'm getting, bottom line here is, you brought a motion suggesting he erred. You didn't establish that there was a surprise or excusable neglect that didn't allow you to appeal timely. and you didn't appeal timely, so you're left with what Rule 60B provides. How have the court not issued a decision? How has the court, by denying your motion, violated the terms of Rule 60B? 6, you didn't even use any of the other provisions. You used 6, the most extraordinary relief provision. So help us through that problem.
I think that you only grant a Rule 60B under extraordinary circumstances where the ruling is a clear miscarriage of justice. If it's a close case or something like that, I agree. You don't use 60B. But I think that because what the court did was so undeniably illegal that this is a one where it is an abuse of discretion not to grant it, because he didn't have any right to just unilaterally remove the debtor in possession and mess up the whole corporation.
I appreciate your concern about what he did. Why you haven't explained to me yet is why you didn't immediately appeal, if that's what your concern was. Because he was taken out, you had the ability to right away stop this process by appealing the decision, and you didn't. So why waiting 5 months? That was your choice, and you let it all occur before you subsequently sought some relief. So why should we hold you to that?
Okay, well, I think that in all fairness, Coeptis had to take on, at the time that the appeal would have been done, I don't believe, I'm 99% sure I was not counsel, and that counsel ended up being terminated by Coeptis. That's not the counsel that Coeptis wanted, and Judge Montoli is the reason for that. So Mr. Voicenot, he was removed, and then I came back in, and that was the time that it would have been appealed. When I came in, I think that the time had already passed, and I was the lawyer that he wanted from the get-go. So let me just clarify, just to make sure. Your position is the court couldn't do what it did, even though it looks like Section 105 of the code says that a judge is effectively a party in interest and has authority to raise claims and do things that other parties have, number one. And number two, courts can appoint receivers, and every trustee in every bankruptcy case is in effect a trustee, is in effect a receiver under your analysis of what a receiver does. So no trustee could ever be appointed in any case either, because 105B would prevent that. Those are your two basic arguments. No, the trustee can be appointed if an interested party makes a motion. The judge is not interested. If he's interested, there's a conflict of interest. He should be objective and totally neutral. An interested party has to move forward, in which case they can. That's not what happened here.
All right.
Right. You're within your 5 minutes. Did you want to reserve the time or continue, Mr. Barbie?
Was I supposed to address all three appeals?
Yes.
In that 10 minutes?
Yes.
Okay, well then I'll just go ahead and briefly just address the other two. There's also, there was a motion to convert, let me see. Oh yeah, there was a motion to convert the Chapter 11 into a Chapter 7. It wasn't timely filed. What the respondent keep doing, and what they failed to mention, is that the notice was served timely. Mr. Voicenot, I believe, was counsel at that time. The notice, but there was no motion attached. So you didn't know what arguments they were making. It was just the notice. If you go look at the documents to which I referred, Ms. Klump never denied it. When I brought it to her attention 8 days before the hearing, she didn't say, oh, I sent it already. She just sent us an email with the actual argument attached. I tried to bring this to Judge Montali's attention. He just didn't care. So we had 8 days to come up with substantive arguments. When we went to the hearing, I said, we didn't have time, and that's the only thing I could argue. And he said, well, you should have made substantive arguments. But our whole point is that we haven't had time to make substantive arguments. Also, the Chapter 11 was converted to a Chapter 7 for the most bogus grounds. It was really because she had already got all the money that she could get to pay herself. So she said, let's convert to Chapter 7. But there was nothing to convert. All the assets had been depleted. And she brought up things like he's not paying his insurance and things like that. That was her job, because she was at that point, at the time that she asked to convert to Chapter 7, she was the trustee in possession. She was the one receiving the rents.
So
It was
counsel,
her job.
counsel, at that point, the debtor had the ability still to file a plan before she filed her motion to convert. The debtor didn't file a plan, so the debtor didn't take any position with regard to how the rest of the case would be resolved. So her natural position, because she can't file a plan under subchapter 5, is to convert the case. How do you respond to that problem?
I did research on it. The plan was not due yet. It was not due. We did file a summary of the plan that our ideas. There's something that you do before you do a plan, which we did while I was still counsel before I got kicked off the case. I did submit that, but I looked it up. I did my research. The plan was not due. That was a bogus reason. Every reason was bogus. There was nothing. She's going to be doing all this work on the case, and there was no way to pay herself because she had already sold off everything. The last thing that she did, she got compensated all this money for selling the Stockton property. She sold it way below value.
So you appealed from the order that granted her the authority to sell the property, right? Because what you're raising in opposition to her compensation request is an argument that the sale shouldn't have been conducted, yet you didn't seek review of that, did you?
30 seconds. My argument with regards to the sale goes back to the fact that the only reason why she was able to do that is because she was a legally appointed debtor in possession. So if she had not been appointed debtor in possession, she could not have done that sale. But even if she was properly made debtor trustee in possession, it was harmful to the estate to sell that property at approximately $100,000 below value.
All right.
Right.
Thank you.
Thank you for your argument. Right, Mr. Mara, are you going?
Yes, Your Honor. Yes, Your Honor. I will. May it please the court. I think that the Chapter 7 trustees' arguments are laid out pretty well in the two briefs that we filed. I did want to correct a couple of things that Mr. Barbie said. Judge Montali did not kick him out as being counsel. He expressed some concerns about his expertise as a Chapter 11 debtor's lawyer. And he was replaced by a substitution of counsel with Mr. Voisinot. And so to say that he was kicked out is a little bit of an exaggeration. That really is the only comment that I have about what he has just said, but I'm here for to answer questions the court may have.
No, I was just going to ask you, could you clarify his position? I thought Judge Montali determined that the motion that that Ms. Klump filed to convert the case was filed, and the notice was filed, and it was served. Both of them were served on Mr. Voisinot when he was counsel, and that was more than 21 days prior to the hearing that was conducted on May 6th. Is that an incorrect factual determination?
I think it was exactly 21 days.
Right, but it wasn't
yes.
The 28 that he has argued is applicable under the local rule, but under the Rule 2002 provision, the 21-day. But he argues that only the notice was served, not the motion. Can you clarify that?
I can clarify it. Your Honor has correctly characterized what Mr. Barbie's position is on the 28 versus 21. The motion and notice were filed on the same day. I can't remember what it was, date in April the 15th or something like that.
Right.
And Mr. Voisinot, who's an ECF filer,
Right.
received both by electronic notice.
Right.
Mr. Voisinot was counsel of record at the time.
Gotcha. That's what I thought the record revealed. All right. I don't think I have any other questions for you.
Mr. Baker? Right. No, I don't have any questions either. Ms. Klump, would you like to address your fee issue?
Thank you, Your Honor. May it please the court. I will submit on my brief as well. If Your Honors have any questions for me, I'm happy to answer them.
Questions?
I don't.
No, on the fees.
Nope, we don't have any questions for you either, Ms. Klump. So thank you all very much. Thank you for your good arguments, and this matter will be submitted now.